Hi everyone, today I sit down with Tim to do a deep dive into the world of intellectual property and IP law. What is it? How can a firm like ours assist with your intellectual assets? And how to get in touch with us should you be interested. All that and more as Tim and I take a look at the inner workings of IP law in Canada and around the globe. Stay tuned. Hey Tim, good afternoon.
Good afternoon, Chad.
Tim, something that comes up a lot in our marketing when I'm describing the firm to someone and so on is the phrase boutique IP firm. Boutique IP firm. For those who might not know, what is an IP firm and what is IP?
IP. IP stands for intellectual property. You say, what in God's name is that? I understand property. Property is something I can touch and feel and stand on. You can reach down and hold it. It's dirt. But intellectual property adds this angle of it's intangible, almost the exact opposite. These are things that can be ideas, for example, can be intellectual property. Designs, slogans, music, these are all things that can be subject to protection. Why is that important? It's important because new ideas are things we want to encourage and promote. If someone can just grab it right away, then the concept is there would be fewer new ideas, and at least those who came up with them wouldn't get properly rewarded. So that's the area of intellectual property. Now, I'm sure you have a question about that.
Why? Yes, I do. So in that regard, is there a deeper difference between that kind of intellectual asset and something like a physical asset, say a house or a car, or is it purely tangible versus intangible?
They both involve boundaries and protecting rights and knowing where the boundaries are. So think of a house, and somebody's buying a house. One of the things you do is you can go see it, but you're always interested in how much land do I have? Where is it? A 25-foot lot? Is it a 30-foot lot or 50-foot lot? Whatever it might be, and there'll be a survey, and someone's actually measured this carefully, and you can look at it and say, here's where the stake is. I found it, and I can see the boundaries of the thing I'm buying. Well, it's the same type of thing with intangible or intellectual property. There are boundaries. For example, a new idea for some kind of new invention. The piece of paper that you get signifying that is your idea, your invention, is a thing we call a patent. And what the patent office does, it's issued by the government, just like land title. You can go check land title office by the government and they will tell you who owns what land. Well, the patent office will decree who owns what idea and what are the boundaries of those ideas.
How do you help clients identify their intellectual assets?
Well, every business is different, and there's no one size fits all for all the different businesses out there. What I can tell you, some businesses all completely depend on intellectual property, something like a patent. An example would be the pharmaceutical industry, where somebody invests millions and millions, hundreds of millions of dollars in research and development for the products that are ultimately going to be consumed by millions of people. And those products, when they're made, don't cost very much money to make, but the research costs an awful lot. So to those companies, it's very important because once they come out with that product, then anybody else out there, any kind of other manufacturer, could simply make the same thing. And so patents are very important for them. Other industries, it's not quite as important. Now, for example, the software industry, there's a number of big companies. One in Canada I can think of on the stock market. It's had a huge run and it's one of the biggest suppliers out there for online shopping. Its press statements have said they don't care about patents, they don't care about IP, because software is moving so fast and it doesn't depend on that. And our patent office is kind of not seen that as something capable of invention and patenting the same way as others. So it depends on the type of business. Obviously, there's other assets like trademarks. The most famous might be, or one of them, it might be the Nike swoosh. You can't just run around using that. Nike protects that carefully, and that's a key, and it's a key value driver for the business. Is the awareness and public awareness of that unique design with the Nike product, and the comfort that consumers have with the Nike brand.
So, how do companies or corporations in situations like the Nike swoosh, how do they ensure that others aren't going around using those intellectual assets?
Well, if you're going to have property, you've got to have the ability to exclude others from using it, and you have to enforce it. And so this is the angle where I personally come in, the happy litigator, the person a lot of people say they don't want to see. But the reason, for example, that we are out there in this field of intellectual property is that people will encroach on your property. They will not just borrow it, they will use it without paying you. And so you need to be able to bring an action, bring some kind of, ask the court to help you enforce that. Otherwise, it's valueless. It's very important to enforce your rights. They become diminished in trademark terms. The goodwill's diminished. You've allowed someone to use it, and courts actually, if you don't enforce it, they will say you've lost it, the distinctiveness of that asset. So what we want to be as a firm, for companies and individuals out there, is we want to be a partner of them in promoting business and be on the value side of the equation, the investment side, rather than on a cost and seen as some kind of unnecessary cost to an operation. Because protecting your IP is critical to a business and its growth.
Okay, so a company decides to invest in their IP. They hire us or another firm. They go to court. What typically happens then?
That's what's interesting, because a lot of these different types of assets, you can go through them, whether it be a patent or a trademark, somebody's done a preliminary review of that you have an asset. And that's usually the government. In Canada, it's the Canadian Intellectual Property Office. And they've issued this gold seal. And you say, wow, I've got this thing. It says I own this. Almost like in The Wizard of Oz, getting the decree that you have a heart and you've got a gold seal saying you have this special asset. Well, the court sees that, and there's what's called a presumption that you have a valid patent. But that doesn't mean a person you're asserting that patent against can't defend itself and attack the original grant. So there's a laundry list of different things they can attack. And I think one of the things that's always surprising for the owner inventor who is new to the business is how the court can simply undo what they thought they had before. So again, it's got to be carefully prosecuted, carefully done in the first place, and then you've got to be able to defend it. And of course, what the value of that asset is the ability to exclude others, right? And the ability to create what we call higher prices, monopoly pricing, because the fundamental law of economics is more participants, more product out there means lower prices. And so the big value of these intellectual assets is to allow a business to recoup the investment they made and also continue to make good profits for years to come by protecting its intellectual property. On the flip side, of course, there's a consumer angle. There's a public good angle to the whole thing, because I just said monopoly and higher prices. Well, most people don't really want higher prices. They want the great product, but they don't want to pay a lot. And so there's heavy competitive pressure, and some assets, some intellectual property truly isn't valid, hasn't really been properly thought out. And this is the business that we sort out in court. And if it turns out that it wasn't properly granted, then more people can come in the market, more products can be out there, and prices will drop. So the court plays a vital role in managing the balance between innovation and protection and research and access and affordability. And that is that is the business that we're in, is managing that process for clients and individuals.
So you mentioned affordability there. So I wanted to ask, what is the best way to avoid or mitigate some of the expense and the just backbreaking effort of litigation from the company side of things?
Well, I mean, again, I come at it from a litigator's perspective where
Mhm.
things have gone awry, and you see sometimes the mess that's created, particularly if you have started a business, you start using a trade name and a website, you're all excited, you tell your friends and family, and you've got your first customers and you're growing, and then you get what's called a demand letter or cease and desist letter telling you to stop using that name or website or what have you. And that can lead to thousands and hundreds of thousands of dollars of sorting that out. So how do you do it in the first way? Well, you get paper done. You do searches of what's being used. If you have a great idea for a name, well, there's a database you can search to make sure that's not being used by somebody. And you should also, even in terms of your business, make sure that you have confidentiality agreements with employees. These are things that aren't that complicated to put into place. You need to have available to you, and should paper. It's just like papering your house and making sure you have good title. You want to have good title and good paper for the business that you're creating and growing. For a lot of people, it's an afterthought, and they don't want to do it because they're so excited about growing their business, as they should be. What we have created at Gilbert's is a unique model called Slingshot, that is a division of our firm that is geared to entrepreneurs and new startups, that allows you to pay a low monthly price for access to that kind of database of precedents and the things you would need, and consultation with lawyers monthly to make sure that your business is papered properly. So that's an innovative new model. We're seeing it grow. We started last year, and a lot of companies have taken to this because they're getting things done right, but they're not blowing all their money on lawyers, which is a lot of people. Like Shakespeare said, the first thing we'll do is shoot all the lawyers. So not a lot of people see lawyers as partners, but truly we want to be a business partner and see your business grow.
So Gilbert's is, of course, based out of Toronto, Canada. But does IP protection reach across borders? If someone outside of Canada wanted to hire us or Slingshot, how does that work?
That's a good question. We act for a lot of companies from around the world. We act for companies here. IP, a good idea is universal in simple terms. So it's a good idea in Canada. It's going to be a good idea in US and Europe and Asia, all over the world. So if we're talking about it depends on the type of asset, how far you want to push that protection. It's a decision that we make with you, and you can choose to seek to protect it in the different jurisdictions around the world. So you would file protection in Europe and US typically, and in Canada, Australia, that kind of thing. But you might have an asset that you don't think you're ever going to push abroad, and maybe a business asset like a trademark, and you say, geez, every time you file something, it costs money. I'm really not going to go to some place ever. North Korea, for example, would be the most wild example. Rare that a business is going to ask you to file something in North Korea. And then you peel back from there. So it's a decision made every time. But truly, intellectual property is an asset that's protectable worldwide.
Now, speaking globally, now that we're on that train of thought, is there a place or places throughout the world where IP tends to be less respected than others?
Well, people have the perception anyway that it is less protectable in different jurisdictions. For a time, the sense is I would say, democracies as a general matter have the highest degree of protection in the world. Their independent judiciary, which is very important to, as I said, this gatekeeping role that the courts play in ensuring that only valid inventions and valid intellectual property assets are protected. So as you get into more despotic regimes, wherever they may be, and it tends to that direction, you see less of a chance of your invention, especially being a from outside that jurisdiction being protected. And I'm not going to name countries because I'm really not up to date on what the latest is. And some countries that you might perceive to be, less democratic, some of those countries do, in fact, have a great business culture. And so, ironically, they do really push commercial protection. Might be somewhat, less on the human rights, but they're bigger on the so-called business rights. I'm not an expert in those jurisdictions, but it's a lot more perception about protection than it is about what's actually happening on the ground.
So, for any companies, whether inside or outside of Canada, who might be interested in working with Gilbert's, what would be the best way for them to get in touch with us or you?
Well, the best, we have through our website, or me personally, tim@gilbertslaw.ca. Our slingshot model, of course, if you're a newer business and a startup and you're thinking about, geez, I don't want to go litigate anything. I don't want to figure out if something is valid or not. What I'm interested in is making sure it does resonate. I need my business to be organized and I don't want to get killed by fees. I think that's a great model. And that's paul@gilbertslaw.ca or john@gilbertslaw.ca. That are the two contact points for you. And then on the litigation side, obviously we have a number of litigators at the firm. We have deep expertise in a number of the disciplines that our companies are in. For example, pharmaceuticals, chemistry, this type of thing. We have PhDs on staff, the new genome therapies. That helps in terms of understanding the problems that you have and communicating with someone who gets it. So we would be happy to help.
Can attorneys in other countries contact Gilbert's as well?
Yes, absolutely. And the lawyer network out there is vital. We work through referrals. We work through an association. We get filings done for you abroad, and we get referrals from abroad here. Again, if you're also in the litigation side, there are a number of disputes around the world, and for a long time, a lot of companies didn't actually pursue that litigation in Canada. It was perceived as not as important a market. But what they're surprisingly finding now is that the country's grown. We have a lot more people. B, we have the pricing here and uptake of some of the luxury items and more expensive pharmaceutical products, so that we're one of the highest users of biologic medicines in the world. For example, these are the newest therapies and we're getting access to those. So for those kinds of things, they're becoming an increasingly important market. And we also have a very good legal climate here, not just independent, but also what's very important to intellectual property users is the availability of an injunction to stop someone from using your idea without your consent. And our courts have continuously been enforcing injunctions where there's been found to be infringement of a valid patent, for example. So those are all attractive features to working in this market.